वेलकम टू आवर प्रोग्राम ऑन इमिग्रेशन एंड लीगल अफेयर्स। आप सब लोगों को माइकल फुलवानी का नमस्कार, आदाब, सत श्री अकाल। So in this program today we again welcome Mr. David Nachman, who is also an immigration attorney, and we are working together at this time. And you will see Mr. Nachman from time to time whenever we come for this program.
Thank you for having me again, Michael. Thank you.
So in today's program, we want to give you first the cutoff dates for the month of November 2011. Now, every month this visa bulletin comes to us from the Department of State, which explains how the cutoff dates for all the categories, family and employment, move. And after I tell you where we are in the month of November, how much they moved, we're going to talk a little bit more about the visa bulletin and the importance of the visa numbers becoming available in some cases. Okay, in the family preference categories, the unmarried sons and daughters of US citizens, which is the first preference, it advances by 5 weeks for all the countries to July 22nd, 2004. Family 2A category, which is for the spouses and children under the age of 21 of green card holders, has a fairly good news, advances by 5 weeks to February 15, 2009. Family second preference, which is the unmarried sons and daughters over the age of 21 of green card holders, advances by 2 weeks to August 1, 2003. Family third preference, which is the married sons and daughters of US citizens, for all the country, advances by 2 weeks to September 22nd, 2001. Family fourth preference, which are the brothers and sisters of US citizens, advances by 4 weeks, is still a good news, to June 15, 2000. Now, with regard to the employment preference categories, the first preference, which is priority workers, which is current for all the countries, including India. The second preference, the advanced degree holders, is current for all the countries, most of the countries, I would say, except India. India, you know, has always been a backlog on the second and third preference categories. And the second preference category for India is a good news, advances by 14 weeks to November 2007. The third preference, which is for the professionals having people have a college degree or skilled workers, it advances by 2 weeks for most of the countries except India to December 22nd, 2005. For India, which is much, much behind the other countries, it advances by only 1 week to July 22nd, 2002. The other workers we call the EW category, basically those people who have a sponsorship based upon less than 2 years of experience or unskilled, like nannies and household workers and all that. That is in the third preference, but a separate part of that. For most of the countries except India, it's still good news, advances by 8 weeks to November 15, 2005. But for India, again, it only moves by 1 week to June 15, 2002. The fourth preference, which are special immigrants and which have the religious workers, religious priests, is current for all the countries. And the employment fifth preference, which is for investors of $1 million or $500,000 in the regional center, again is current for all the countries. Now, I want to give you a little request to Mr. Nachman to say anything you want to make a comment on the advance movement of cutoff dates. Well, especially we were talking earlier about the Indian second preference and the third preference.
Well, I think, Michael, you and I were saying that there seems to be an increased gap now in the difference between the dates on the second and third preference. So if anything, that to me signals an opportunity or the need for folks who are waiting a long, long time on their third preference classifications to consider second preference. And in order to even buttress that argument, to make it stronger, is the fact that now the government has recently promulgated additional information that goes to this entrepreneur and investor, where they're looking at entrepreneurs and investors in a very good light. And so there is much more positive thinking, I think, behind going forward and doing EB2 cases if you can.
Okay, something else I want to talk about, importance of the cutoff dates when they advance. What are the things that people should be looking into? First of all, the rule of cross-chargeability that we have mentioned previously on many other programs, that if your spouse is born, let's say you are born in India, and your wife or your husband is born in some other country, which the dates are better. It could be Pakistan, Bangladesh, Nepal, or any of those countries, Afghanistan, Middle East, African countries, because a lot of Indians are born in other countries too. So it is quite possible that our main person beneficiary of the petition was born in India, so he has to stay in that line. But if the spouse was born in a different country, then he can get the place of the spouse's country of birth, which could be excellent for employment second preference category. For example, it's 2007 for India, but current for other countries. So this person who was born in India, he can take the place of the wife's country of birth, and which is current. So that's one very important factor. The other item that is about Child Status Protection Act. When the children age out over 21, we have the Child Status Protection Act, under which there's a formula that we calculate as to whether this child who aged out over 21 can also qualify. But that also has to do with the availability of the visa number, because this calculation is based upon when the visa number becomes available. Then we look at the time that immigration took between the filing and approval of the petition, and the age of the child when the visa number became available. From that age, the difference we minus, and to see by doing that he goes back under 21. So that's another important factor. Also, listen, you might have filed a case many years ago, labor certification, I-140, but you couldn't file 485 because you cannot file, because the visa number has to become available in order for you to file a 485. Of course, if you are eligible, not every person.
Right, the priority date has to be current.
That is correct. Yeah. So this is another important thing. I mean, your I-130, I-140 should have been approved, labor cert is approved, and you are just waiting for the visa number to become available. And as soon as the visa number becomes available, you can immediately file a 485 for you, your spouse, children under 21. Also, if your family is outside of India, US, for example, and you are filing a 485, make sure also to tell your lawyer to also file a I-824, which is the notification to the American consul to issue the visas to the family members back in India. Not only that, there is a requirement under CSPA that when the visa numbers become available, the child's application, DS-230, and the fees must have been paid within 1 year from the date the visa number. So all these questions go with it. So, for example, this is a very interesting thing, David. You remember in August 2007, when the visa number all of a sudden became available, all the people who they filed, they had I-130 I-480 approved, and they filed the 485, but they are waiting because the visa, that only 1 month that happens, then it went back, and for many years it has been waiting. Now, look at the cutoff dates that I just mentioned. For employment second preference now is 2007, November. So a lot of those cases that were filed there are pending. Those visa numbers are available. They should push their lawyers to contact the immigration to complete, so that everybody can get a green card in the month of November, December. Right. So that is the importance. I think there's a time for a short break. Let us take a short break, then David and me will try to give you some more important information. Stay tuned. We will be back. Welcome back. Just before the break, we were talking about cutoff dates for the month of November 2011 and many other things that go with it. There's just one other thing that we want to mention. David and me, I think in a previous program, did information about the DV 2013 lottery program. There's a lottery program under which about 50,000 people get visas every year. Now, I think we probably not made it very clear that Bangladesh is no longer in the lottery program. First time I've seen in many, many years. Actually, Bangladesh was always number one. The maximum numbers came from Bangladesh. But now what that means is basically India, Pakistan, Bangladesh, and some other countries are no longer eligible under the lottery program. And that's a reminder. The application for DV 2013 has to be filed between October 4, 2011, this month, and before November 5th, 2011. So if you want to apply for the lottery program, do it immediately. Now, David, the H-1B information is, remember we have been saying, don't worry, still a long time to go for visa numbers to become available. Yeah. Now, what do you say? This month we got this information that the H-1B on the bachelor's degree regular, they already reached 41,000, and in the master's degree, which has 20,000 quota, already reached 19,000. What would you suggest now to people to do? They are so close now.
Well, Michael, I think that it's interesting to see that the master's level H-1Bs have been absorbed so quickly, and it actually is a tribute to the fact that they created this 20,000 for master's level H-1Bs, because essentially what this was an attempt to keep highly skilled workers in the United States to prevent them from going abroad. And that's why they carved out the 20,000. So it's good to see that those are being used.
But interesting thing, David, they did that because all those numbers under the regular H-1B were
being
getting
resorbed.
used up fast.
That's right.
So the master degree holders were not getting a chance. So what they did, they wanted to give priority to the master degree holders. That's now right. It's the other way around. Master degree are gone, but the category that is the bachelor degree still continues.
Exactly.
But it doesn't matter, no. Even if the 20,000 masters are gone, they can still apply.
The master's degree people can still be applying in the normal bachelor's classification.
So you will agree that this is the time, don't wait anymore. If you plan to apply, just go ahead, right?
Absolutely. I mean, we've been telling our clients, of course, not to wait too long. What we tend to find, Michael, is as the H-1Bs resorb and you come closer and closer to the caps, what ends up happening is that the government seems to be issuing more arbitrary RFEs. So now is a good time to apply to avoid those really, really nasty RFE documents where they're asking for information which you may have already submitted on the first round.
So, but they count that also, even if the RFE is issued in a case, it is counted towards. In other words,
that's right.
Once the RFE is responded and it's approved, it still is fine.
That's right. But generally speaking, at least statistically within our office, we did some statistics to try to figure out, how H-1Bs are being processed. What we noticed is that H-1Bs seem to be going through without arbitrary RFEs earlier in the season. When you get closer and closer to the approach at the cap, the government seems to issue arbitrary RFEs, I think, to almost slow the process down a little bit for themselves.
So the recommendation is
apply
find
now.
An experienced good lawyer so that
Absolutely.
you don't get too many RFEs, or you get RFE, a good lawyer can definitely provide the information and respond to the RFE in a manner that it is accepted and our client gets the H-1B.
Right, and that's lesson number 2. Lesson number 1 is get your H-1Bs in as quickly as possible. Right?
Here is a question from one of our viewers, and let me read the question. This gentleman has got a H-1B visa. He's in valid status. And he has got a stamp on the passport, valid to December 2011. Now, the wife's the H-4, and her father is sick, and they want to go to India for 2 or 3 months, that means they'll be coming back after December. So it is therefore important for them to go to the American consulate to get a new visa stamps. Obviously, first thing that they have to do is to apply for extension. Because in order to go to the consulate and apply for a new stamp, they have to show to the consul that their period of authorized stay has been extended by another 3 years or whatever it is.
Correct. They have
now,
to have the new.
His question is this. He says that a lot of my friends are telling me that if we go to India and both of us apply for H1, H4 stamp, there is a lot of risk there, because in many cases they are harassing, they are denying it, they are asking lots of questions. So what is our suggestion? What is that right? So let me just say that, yeah, to some extent it is true. They are very closely scrutinizing visa applicants, their background, their information, degrees, diplomas, everything. not just in the H-1B cases, David. I mean, I have been encountering problems and seeing many clients in other categories in immigrant visas, non-immigrant visas, family cases, husband, U.S. citizen filing for the wife, for the parent or any. They're going through a lot of questions, but to some extent I understand there's a marriage fraud, there's other fraud, so consuls are required to see, but I think it's getting a little bit too much to the say that when you are looking at marriage, whether it's bona fide or not, they want the marriage photos, they want the Kankotri, they want all the information. And even then, sometimes when they have a doubt, they conduct a field investigation to go to the houses and talk to the neighbors. Right. So any applicant, I'm not just saying we answer to the question right in a minute, but I would recommend that any person is going to the American consul applying for any kind of visa, be fully prepared. I mean, I had a couple of cases when a U.S. citizen filed for the parent, okay? IR petition, simple that they goes and gets the visa. Consul goes back to the history of that son who came to US 15 years ago. And then he got a green card, he's a citizen. Consul wants to know, how did your son go to US? It starts from there. How did he get the green card? How did he become a citizen? Right. And some people make a mistake, say something which is not accurate, and then they charge them either with a fraud or they deny the case. So you have to be very careful.
Well, I think, Michael, what you're voicing, which I agree 100% with, is that the practice of immigration law has changed dramatically over the years. 10 years ago, I think you and I would not have thought twice about handing a client an I-797 approval notice and sending them back home to go to the consulate themselves and getting the visa stamp. And now, for our office, consular processing has become a separate procedure altogether. Exactly. Where we sit down, we coach our clients, we speak to the employers, we make sure that the information the employer is giving to the employee is accurate, we make sure that the employee knows what their job functions are, they know what they're being paid, they know how they're being paid, and every little detail about the H-1B, they have to know when they go back to the U.S. consulate abroad.
We have to take a short break, and right after the break, we'll continue further discussion on this issue. So stay tuned, we will be back. Welcome back. Just before the break, we were talking about one of our viewers' question, who is on H-1B visa, the wife is on H-4 visa, and that stamp is going to expire in December 2011. He will be returning in January, so it is important for him to go and get a visa stamp from the American consul. And basically, his question is that he's worried. A lot of people are telling him that when you go to India, they're going to ask you a lot of questions. They'll keep the case pending for months and months. They may even deny in some cases. And I would say yes, there is a increased intensivity in terms of consular asking many more questions than they used to ask in the past. So you have to be fully prepared. I mean, basically, consuls are starting with, when you go and apply for H1, H4, the consul is starting to look at all your papers, the I-129, where the LCA, where were you working, they want to see the documents, they want to see the tax returns. I have noted that frequently they go on the website of the company to see what kind of business they have. They are in the consulting business, but that doesn't mention anything about consulting the other way around. And sometimes based upon that, they give them a big laundry list, we call, of different documents, and a lot of those questions are not relevant. A lot of questions, I've seen cases where they want the contract between the petitioner and the end customer. Actually, there's no end customer also. So, but you have to very clearly understand what the consul wants and be fully prepared. So
what's even, actually, Michael, what's even more troubling is that some of the consulates are asking for information which is proprietary to the corporation, which the individual may not necessarily have access to. In other words, why would the company be giving the individuals to third-party contracts that the company is doing? That's a little more troubling for us, and it's information we can't even provide.
I have, during my meetings with American consuls, I said, if you are asking IBM, give a list of all your employees and what they do. My God, It take them a whole year to give a list of IBM.
That's right.
But even if a mid-sized company for 400, 500 people, there's a privacy issue also. And you are giving information, of course, they say you are giving to the government, but it's still it's too much burdensome. So if you have a good lawyer that he can explain the position of the company, get maybe a letter from a CPA, get some other documentation which can clearly satisfy the counsel.
Secondary evidence.
Secondary evidence.
Exactly.
But again, what I'm saying to this caller, that be fully prepared. Now, question is sometimes a strategy issue. If I feel that there could be a problem, I would tell you don't go, let your wife go and apply for H4 visa. So if the counsel has any questions, he's going to ask your wife to get from the husband. Now, couple of cases, the counsel told that wife, tell your husband to come and appear with you. Again, the Department of State has clearly said that's not required, it should not happen. So, I mean, these things, why am I saying, why am I telling you? We have been in the business for a long, long time.
And it's happening.
I have seen so many cases like that happening. I have had meetings in the Department of State in the liaison, and we have seen these questions being raised to the State Department that this is happening in the consulates, and the State Department has agreed with us, given guidelines from time to time, but sometimes the years go by that advisory went in. In the meantime, a lot of young new consular officers come in and they do things like bring your husband here or give us the whole list of documents. They have a list on a computer they print out and give to them, which may be applicable or not applicable. Also, I tell you, consuls go much beyond the documentation or the requirements of the H1 status of the principal alien, like the husband in this case. A couple of cases, they wanted to know, how did your husband go to US? Now, if he came on a visitor visa and changed to H1B, they want to see within how much time that happened. He came on a visitor visa and after 3 weeks he applied for H1. They say preconceived intent. You had that fraudulent intention to do it. Come on, this guy's already been there 3 years, 4 years working. But they do raise these questions.
Right.
And my always the contention is that you don't re-adjudicate the petition. Basically, Immigration Service had the same information. You applied within 3 weeks or 4 weeks and give the explanation. They accepted it. Why you want to go back and dig the holes? But unfortunately, that happens. But I don't see much problems when the person came on a student visa. He went to college 3-4 years, then changed to H1B. That issue does not come in those kind of situations.
Right. I would agree, Michael. And I think that one of the, probably the most troubling thing is that if you have a situation where the spouse is seeking an H4 and then the consular official is opening up the issue with regard to a spouse who's in the United States on different visas, that's even more troubling because that's not even a question that's before them.
That is correct.
That's a question that's completely extraneous to the case altogether. And so there clearly is something wrong with what would be going on if that's what's happening.
Bottom line is you have to be, your wife or spouse or children have to be fully prepared when they go to the American consulate and apply for the visa. Because the consuls are also looking into the bona fides of the qualifying relationship of husband and wife. Now, unfortunately, there have been some fraud cases too. So I'm not saying consul is completely wrong, but based upon the interview, based upon certain facts, the consul may have a doubt. And then he puts the case under investigation, section 221G, don't contact us and we'll contact you, which may mean they want to conduct a field investigation. But the problem happens in those cases, especially bona fide cases, just because a consular suspicion, this man is waiting 6 months. Employer says, either you come back, otherwise I cannot wait 6 months for you. I have all my clients waiting for you to come back. So I don't know how we resolve some of these issues, but then of course there are security clearance issues sometimes, but that's nothing we can do. That's a matter of getting FBI clearance or clearance from concerned authorities. So basically bottom line is you have to be fully prepared when you travel outside of the United States, go to an American consulate, be prepared for all these things.
That's right.
What about the option of going and applying in Canada? I would say that my understanding is Canada is not taking cases where a person came on a visitor visa and changed to H1. They say, go back to your country.
So Michael,
but
you're
in those
asking...
cases, like a student, he went 4 years in the college, he did a US degree, then he changed to H1, and then he's going to the American consul. I believe Ottawa is doing that now, the H1Bs.
Yeah, well,
which is an option. It's a good option because the consular officer in Canada or little more inclined to say student 4 years to college, there's no issue of intention or anything?
Well, with regard to changing status or doing what's called third country processing,
Correct.
TCP, we generally advise our clients to only if they have U.S. baccalaureate, master's, or PhD degrees to be looking at third country processing up in Canada. The Canadian offices generally will not entertain cases where you don't have U.S. degrees.
This is exactly what I said in this kind of situation. It's worth a try, getting to Canada, getting a stamp.
You can try.
And then when you go to India, you don't have to worry about the visa.
That's
because I have seen my clients going to India who have to also get the visa stamp, and half the time their mind is what will happen, what will happen. If they have a visa stamp already issued by Canada, forget going to the consulate, enjoy, have fun, and spend time with their family, friends, and come back with peace, sleep the night peacefully and all that.
Agreed. That's that's the benefit, of course, of third country processing. And when we have multinational executives who are traveling from country to country, we would also try to see if we can get third country processing done before they're moving on to the next country.
Now, we have a number of other subjects that to talk about, but I don't think we have much time into this program. But just for the thought, I mean, the next program that we will probably do shortly, we would like to cover some important subjects that you want to mention today.
Well, I thought, Michael, one of the questions which we get frequently has to do with affidavits of support and how to deal with the I-864 for family-based cases. One of the other questions that we get frequently has to do with whether or not you should do labor certifications. You should have 2 labor certifications. If you have 1 labor certification, for example, that's under audit, whether you can do a second labor certification. And then, of course, that also segues or dovetails nicely into the issue of if you have an EB3 case out there, should you try to do an EB2 case? And obviously that sort of finds its genesis in the issues that we were talking about before when we first came on, talking about the priority date backlogs.
Thank you very much, David. All these subjects and many more we will cover in our next program. Please keep watching TV Asia every Saturday at 1 p.m. See you again next week, Saturday, 1 p.m., same time. Thank you very much for watching the program. And David, thank you very much for coming on the program.
Thank you so much, Michael. Thank you.
When writing your questions to us, please let us know the city and state and how you're watching TV Asia. Dish, satellite or cable. If cable, the name of the company and the channel number. Thank you.